I am Taso Pardalis, and my firm here in New York City is Pardalis and Novica. Thank you for joining us. Today, we're going to be talking about marijuana. Well, actually, medical marijuana, and what problems are presented when dealing with that in the workplace. Let's jump in and let's talk about a case that just happened here in New York City. Agatha, a young single mother, worked at a big name automobile supply chain, something like Pep Boys. One day, Agatha was terminated from her job. The reason? Agatha was told that she failed a drug test. Agatha explained to her boss that before the drug test was issued by the company, she was prescribed medical marijuana to help her manage chronic pain that she got as a result of an injury that she obtained while working at the supply company. Her boss told her that they would look into her claim and that they would get back to her. They wanted to check her claim that she had been prescribed medical marijuana, and about a week later, they did indeed get back to her, and Agatha was informed that she was being fired because she tested positive on the drug test. Thank you, goodbye, good luck. Okay? In this situation, what does Agatha do? Well, Agatha should go to a lawyer. And what would that lawyer do? Well, we would first tell someone in Agatha's position that they should immediately file for unemployment benefits. Agatha would explain on that application that she was wrongfully let go from her job and that she was fired for testing positive for medical marijuana. We would then prepare a letter and we would send it to Agatha's boss explaining very politely that it is against New York law to fire someone just because they're using prescription marijuana. In the letter, we would then request, again, very politely, that Pep Boys reinstate Agatha. Okay, no harm, no foul. Maybe pay her for the time that she missed because of the wrongful termination. But most importantly, we want to get Agatha back on track so we can have her income flowing so that her bills can be paid. If Pep Boys in that instance, comes back and refuses to play ball, well, then when they get sued at that point, because in New York, patients who are certified as being qualified to receive a prescription for medical marijuana are actually deemed to have a disability for the purposes of New York's anti-discrimination laws. In a nutshell, what this means is that employers cannot discriminate against employees or job applicants on the basis of lawful use of medical marijuana. Okay? So, let's talk about the current law on medical marijuana in New York. Medical marijuana has been legal in New York since the Compassionate Care Act was passed in 2014. Unlike the medical marijuana laws of many other states, the New York law contains a non-discrimination provision that basically says and provides protection for medical marijuana patients with regards to their employment. Other states that have explicit non-discrimination provisions incorporated into their medical marijuana legislation are Arizona, Illinois, Delaware, Maine, Nevada, Minnesota, Rhode Island, and Connecticut. Okay, New York's public health law states that anyone certified as a medical marijuana patient is deemed to have a disability under the New York State human rights law. So what that means to employers, employers, when you are confronted by a worker who has been prescribed medical marijuana, you are required to engage in an interactive process with the employee to determine what reasonable accommodations may be necessary to accommodate the worker who is a certified medical marijuana patient. Okay? Of course, there are limitations on the protections given to employees. The non-discrimination provision, it doesn't bar the enforcement of a company policy prohibiting a worker from performing their duties while impaired by marijuana. Okay? And also good news for business owners is that New York law does not require any business to do anything that would put another person or business in violation of federal law or cause it to lose a federal contract or funding. So, even though many states have passed legislation allowing medical marijuana use, the Federal Controlled Substances Act still lists marijuana as a Schedule 1 banned substance. For example, businesses in New York with commercial drivers, subject to regulation by the Federal Department of Transportation, must be aware that the DOT has explicitly stated that medical marijuana users cannot meet DOT drug testing requirements despite the existence and the protection of state marijuana laws, okay? Now, let's talk about some employment cases concerning medical marijuana that were actually brought to my attention by our law clerk, Demetrius Mano, who coincidentally is the co-founder and CEO of Bloom Express, a CBD company, okay? The conflict between state and federal marijuana legislation has generated varying court opinions from several different states regarding employers' rights and responsibilities when it comes to employees using medical marijuana. The first prominent case is Coates versus Dish Network, which originated in Colorado. Here are the facts in Coates. A worker using medical marijuana in accordance with state medical marijuana laws was fired from his job because he failed the drug test. He then sued his employer under Colorado's law that prevents employers from discriminating against workers for engaging in any lawful activity outside the scope of their employment. Despite the fact that the employee's marijuana use was legal pursuant to state medical marijuana law, the Colorado Supreme Court found that medical marijuana use was not a legal activity because it was illegal under federal law, and the employee's case was dismissed. Many state and federal courts, including courts in California, Washington, and Montana, have issued similar decisions. Other state courts have issued decisions that were not favorable to employers. For example, the Massachusetts Supreme Judicial Court held that a patient qualifying for medical marijuana use can sue her employer for handicap discrimination. And also, a court nearby in Rhode Island found that state medical marijuana legislation prohibiting discrimination against medical marijuana allowed a worker to sue her employer for employment discrimination. All right, so what about New York courts? Well, there are currently no reported decision from state or federal courts in New York regarding the law's non-discrimination provision. In 2017, the New York City Office of Administrative Trials and Hearings held that the Taxi and Limousine Commission could not revoke a taxi driver's TLC license solely because that taxi driver was certified as a medical marijuana patient. So because that case was determined by an administrative court, it's really of limited value to New York employers because the TLC tribunal, it really has no binding authority on the state and federal court judges. So what exactly is the impact on employers here, okay? Well, the impact of state medical marijuana legislation nationwide will vary from employer to employer, but we have recommended to our business clients some adjustments they can make right now to assure they do not violate New York's non-discrimination provision or to not jeopardize the receipt of federal grants and federal funds or federal contracts, okay, as a result of their efforts to comply with the New York law. So, you know, many companies have federal funding or they're in federal contracts and we want to make sure that you don't lose that, okay? So here are some of the suggestions we made. Revise your drug testing and substance abuse policies. It's important to note that zero tolerance policies will lead to non-compliance with New York laws. If you have a zero tolerance policy at your company, you will be in non-compliance of New York law, which means get ready for marijuana discrimination claims, okay? They're coming. Number two, we advise everyone to engage in the interactive process that's required to determine whether accommodations are necessary for any worker who is known to be a certified medical marijuana patient. So you must have a policy and you must engage in an interactive process with any worker you know is a certified medical marijuana patient, just to make sure that you don't expose yourself to any discrimination claims. Three, become familiar with state marijuana laws in any other states where you may operate. You know, while you may have familiarized yourself with New York's law, if you operate in Connecticut, in Massachusetts, in other states, you want to know what the rules are there and how they differ so you can behave accordingly, okay? So here, when we're often asked by businesses how they can verify if an employee is actually certified to receive a medical marijuana prescription. So very often an employee will come and say, my marijuana is prescribed and I have a medical license to use it. Let's talk about how employers can verify that properly, okay? And there's something called the Medical Marijuana Registry Program. The registry is basically a portal where New York patients register for identification cards and are granted access to cannabis from approved dispensaries, okay? As of July 2019, There are 40 open and operating dispensaries throughout New York State. Keep in mind now that the cultivation of marijuana and the home growing of marijuana for any purpose is not permitted under the law, okay? So to register, patients must first contact a practitioner registered with the Department of Health, and they must be certified with a qualifying condition. Right now, there's more than 1,700 practitioners registered with the state. Patients must be New York residents or they must be temporarily residing in the state for medical treatment purposes. And in New York, the following conditions are already approved for medical marijuana access: ALS, cancer, chronic pain, epilepsy, HIV and AIDS, Huntington's disease, inflammatory bowel disease, multiple sclerosis, various neuropathies, opioid replacement, Parkinson's disease, post-traumatic stress disorder, PTSD, and spinal cord damage causing spasticity, okay? Once patients are certified, they can create an account online, and once approved, they receive a temporary ID card. That temporary ID card can be used in conjunction with a government-issued photo ID to purchase approved medical marijuana until the permanent registry ID card arrives. Registrations expire when the certification issued by the medical practitioner expires based on the prescription. Patients and caregivers must re-register each time a new certification number is issued. The state charges a $50 application fee for patients and for caregivers, but the fee may be waived or reduced if you can show financial hardship. So New York has very much loosened the requirements for qualified practitioners, and as of recently, the list of health professionals who can certify patients was expanded to include nurse practitioners and physician's assistants. So nurses and PAs in certain instances now can also issue and prescribe marijuana treatment, okay? Practitioners, however, are required to complete a Department of Health approved education course and create an account and register with the health commerce system. So for workers, it's important to keep their status updated and have their ID card with them to prove that they are bona fide patients. And for employers, it's important to know that you can ask for production of the ID card to validate the worker's claim that they are certified and have a medical marijuana prescription, okay? Now, there is no doubt that medical marijuana can be beneficial to patients in a number of different ways, including pain relief, reducing nausea in cancer patients during chemotherapy and to enable them to eat, the relief of glaucoma by reducing the intraocular pressure of the eye, treating insomnia, and reducing spasticity. You know, spasticity is a condition in which muscles stiffen or tighten, preventing normal fluid movement. You know, the muscles remain contracted and resist being stretched, affecting movement, speech, and gait, you know. But you know what? There are dangers with many prescription drugs, and this is just one of them. Another scenario that a lot of people kind of avoid speaking about when they speak about medical marijuana is that medical marijuana can be addictive. And, you know, one of the major risks associated with medical marijuana is that cannabis today is about 20 times more potent than it was in the 1960s. You know, and the medical benefits of marijuana are associated with compounds known as cannabinoids, of which there are around 80 present in marijuana. So there's about 80 cannabinoids present in marijuana. The most well-known of these cannabinoids is THC, the chemical responsible for getting smokers high. So cultivation of marijuana over the years has steadily increased the amount of THC as compared to the other cannabinoids. So today, the drug is now far more powerful in terms of getting a user high. While on the other hand, many of the other cannabinoids that contribute to the medical benefits of the drug are less prominent. So consequently, guys, medical marijuana is increasingly addictive, whether it's prescribed or not, okay? So just to clarify, you know, because we're talking about medical marijuana here, recreational marijuana is not yet legal in New York, okay? Possession of amounts of up to 2 ounces was decriminalized in 2019, but it is still a violation under New York law. It's just not a crime. So marijuana use is still illegal, and as is personal cultivation, smoking marijuana in public, or the sale or gifting of any amount. All illegal still, okay? If the police catch you, you are going to have to go to court. You're going to face the possibility of paying a fine, It's $50 for amounts less than 1 ounce and $100 for holding any amount between 1 and 2 ounces. And it's still possible that you can be arrested and processed. Even though that's not the policy, it's still possible. Okay, so a warning, even legal medical marijuana can still get you arrested, okay? So even legal medical marijuana can still get you arrested, okay? Another major issue to consider here is that, you know, uh, for one thing, marijuana is not recognized for medicinal use under the federal law at all. This is state law specific, okay? So you could still be arrested and convicted for a drug crime if you were caught by a federal law enforcement officer, for example. And the same is true if you transported the drug, medical marijuana drug, across state lines into a state where it has not been legalized, okay? So even in states where it is legal, a user can still be arrested under several different circumstances. You might get caught possessing more than the permitted amount from one state to another. You could be discovered to be growing more plants than you are permitted in one state than another. You could even be arrested for driving under the influence depending which state you're in and have your driver's license suspended, okay? So, so now that we've talked about all these things, let's jump back to the beginning where we talked about Agatha and her termination from Pep Boys for using prescribed medical marijuana. Agatha was fired from her job. She was told that she failed the drug test. She explained to her boss that she was prescribed medical marijuana. Her boss told her that they would look into that. And about a week later, they got back to her and she was fired because her drug test was positive. So there's still a lot to be discovered about Agatha and her case before anyone can tell whether she has a claim for discrimination against her boss yet, okay? So here's some questions that need to be answered. Did Agatha have a medical marijuana registry program ID card? Did her boss engage in an interactive discussion about whether an accommodation could be made so that Agatha could safely perform her work while being medicated? Okay. Was Agatha's certification done by an authorized healthcare provider? Does Agatha's employer, does Pep Boys in this situation have a medical marijuana policy? And was Agatha fired for real because of her drug test results, or was it because of poor job performance? As you can see, it's not as easy as the initial fact pattern, and each case is extremely unique, and you have to analyze these things. So I hope this was helpful. That's it for today. See you in the comments. Though medical cannabis is legal in New York State, there is no prescription for medical cannabis since it is not federally legal. A medical professional only can recommend, not prescribe. That is correct. Sorry if I used the word prescription, just a habit from all the years of seeing doctors and visiting them. Does Kansas and other states that hold your blood screening test even with disabilities? So good luck. Yes. Yes, yes, yes. For employers, it's really important, I think, to adjust your handbooks and your manuals and your rule books for employees if your policy is that you do not want employees performing their job duties under the influence of medical marijuana. So that's the first step, is adjust those handbooks and those rule books. The second thing is, whenever an employee does bring this up and if the employee says, hey, I have a prescription, that's why I failed the drug test. It's okay, let me see, the registration. Um, Let me see you on the registry. Let me see the card. Let me check the provider who issued it to you and make sure that everything's kosher. And for employees, for you guys that, have or maybe prescribed, well, sorry, maybe certified, sorry, Marie, not prescribed, force of habit from years of seeing doctors who may be recommended medical marijuana. It's important that you maintain your ID, you maintain the certification when the renewal comes along, all right? So just a short recap there. Thank you guys for joining. This was really awesome. I really enjoyed this topic. I hope you did too.